Welcome back to the Story Lens podcast, where your story is our focus. You know, a question we get a lot is, what is the difference between an irrevocable trust and a revocable trust? So we went out and found a sophisticated attorney to answer that question. So today, Erin Anderson joins us from Kemble, Woods and Martinson. Erin has 26 years of experience in estate law. She's also worked as lead counsel for a trust company, so has a deep breadth of knowledge in this space. We look forward to the conversation and learning from Erin. Thanks for joining us. So let's get started.
Welcome to the Story Lens podcast, where your story is our focus. We explore wealth, legacy, and purpose through a process that starts with deep listening and leads to one-of-a-kind strategies. At Story One, we believe the best planning begins with you.
Erin, you've been practicing law for 26 years.
Yes.
You focus in estate law, but also, you know, you worked as a trust officer as well, a lead counsel for the trust department.
Yes.
Yes. Okay. Thank you. Yeah. Sorry, I didn't mean to be,
No, trust officers are great.
Yeah.
I just didn't do it.
Just not what you did.
It's not what I did.
Okay. Yeah. So you've been an attorney for 26 years. You've practiced in estate law. You've also been, lead counsel for a trust department of a large bank. And so you've sat on both sides of the table. You've really just been inundated in estate law and practice for some time. And so you have a broad expertise. But today we're going to start with a conversation, kind of bringing it back to two terms that are often used and probably more often misunderstood, which is really just this idea of a revocable trust and an irrevocable trust. Some people say irrevocable, some people say irrevocable. But they're terms that are often used when you're jumping into estate planning. And I think we've all sat across the table from a client, use those terms, and they look at us and they just kind of nod their head like, yeah, I get it. And you kind of know like, you probably don't understand what I actually said. So can you start us off with just give us a rundown on those two different instruments and how they differ?
Sure. An irrevocable trust is a trust agreement that's created by the grantor, but the grantor does not retain the power to amend or revise or restate the agreement. He does not have, or she does not have, that power. So with regard to a revocable trust, the settlor can amend, revoke, restate the trust agreement. And the trust agreement itself, it does primarily the same thing. It's created for the benefit of the beneficiaries of the settlor. It has trust powers. It appoints trustees. They both avoid probate. So in terms of what they're trying to accomplish is the same. They go about it in different ways.
Yeah. And you jumped into a couple terms that, again, common in estate planning, but settlor and grantor. Break those down for us real quick.
Settlor, grantor, trustor, that's the person who creates the trust agreement, whether irrevocable or revocable. They are the creator of the trust agreement. And the trustee is the individual that is in charge of administering the trust. They're the ones, the decision maker. So with regard to the assets in the trust agreement. I often tell my clients that are involved in business to think of it like an LLC. You have an operating agreement, and the operating agreement will provide how that manager should manage the assets that are titled in the name of the LLC. Well, that's similar to a trustee of a trust agreement. The trust agreement sets forth the terms, and the trustee is basically the manager and decides how those assets should be invested or when to make distributions. But the decision-making ability falls mostly to the trustee.
Yep.
Let's add one more person in here. And this is somebody that, again, it's funny because you say it's new, and we say it's new, it's like 25 years old, or become more popular in the last 25 years, and it's a trust protector. Talk a little bit about that role and how, in particular for higher net worth families, that trust protector role is somebody that we can use or somebody that is important. So talk a little bit about that as well.
So we've mentioned that an irrevocable trust is a trust that the grantor cannot make changes to amend or revoke. But in an irrevocable trust, you could appoint what is called a trust protector. And that trust protector is usually an unrelated third party, somebody that is not subordinate in any way to the grantor, just an individual, a standalone individual. And that individual can, for certain circumstances, under certain parameters, make changes to the trust agreement. It might be able to say, make a change if for income tax purposes, if the way that you thought when you created the trust it'd be taxed as one way, but you've determined that no, I don't want it to be taxed that way, I want it to be taxed differently, you could have the trust protector is allowed to make amendments, but only in certain circumstances. Or if there's a change in the family dynamics, a trust protector might be able to come in and then make a change to the irrevocable trust. So to say an irrevocable trust is not revocable is not, or amendable is not a correct statement, but in most cases it is not amendable or able to terminate by the grantor on their own.
Well, a lot of times what we're trying to accomplish with an irrevocable trust is to get assets out of someone's estate, someone's taxable estate. So if that grantor were to have the ability to change the trust, or if 10 years later they come back and do a bunch of things to change the trust, then potentially every asset in that trust then
It's brought back into their estate.
So we're trying. So this is actually what we're trying to accomplish is we're trying to alleviate the grantor of really authority.
Right. So if the grantor doesn't, if they relinquish control over the assets, then they will not be included in their taxable estate for federal estate tax purposes. But if they hold on to too much control, the IRS will say, no, nice try, and bring all those assets back into their taxable estate.
Their gross estate. Yep.
Which is oftentimes, like when families come to you to start with, depending upon their net worth, they might start with a revocable trust. That's a common first step, right? I'm not sure, we're going to make some changes. We have young children. We want to make sure we have guardians protection, et cetera. But as their net worth grows, particularly around that $30 million number for a married couple, right now we're talking about estate tax. And that's where the irrevocable trust really becomes a much more common tool. And so this idea of getting money off the balance sheet, another one of those things you say in a meeting sometimes, it's intuitive to us, but let's talk about what that means a little bit. So you fleshed it out, but say some more about what happens when a grantor or someone who comes to your office and says, I've been told I should have an irrevocable trust. Like what happens when they take their business or some of their assets and put it in an irrevocable trust?
So if you're able to either by gift or sale transfer assets to an irrevocable trust, that asset itself will not be subject to a federal estate tax, but also the growth, any sort of growth or appreciation in value also will not be subject to estate tax upon the grantor's death. So if I have $1 million and I gift it to an irrevocable trust and over 20 years it grows to 20 million, and then I pass away, the $20 million that is in an irrevocable trust will not be subject to estate tax. But if I had the same $20 million in my revocable trust when I pass away, then because the estate tax exemption for a single person is $15 million, $5 million of that amount will be subject to a 40% tax. So, and any growth, any appreciation is all subject to estate tax if it's held inside your revocable trust, opposed to an irrevocable trust.
Yeah. And something a lot of people may not know is when they're creating a revocable trust, when they die, that trust becomes irrevocable. Can you talk just a little bit about that process?
It does. So the revocable trust is set up to provide during life. It provides for the grantor. So during life, if the grantor becomes incapacitated and can no longer make financial decisions for themselves, the trustee, a trustee would step into their shoes, and they would make the decisions and provide for the grantor. Upon the grantor's passing, the revocable trust then becomes irrevocable. It is now set in stone. What has been said is said, and now it becomes an irrevocable trust, and it's set up for the benefit of their beneficiaries.
Yeah. So when I think about kind of who may be listening to this, probably the thing that is most interesting is this idea of, okay, I own a business, or I sold a business 5 years ago. My net worth has grown and grown and grown. I set up a trust 10 years ago, a revocable trust. And now I'm starting to see this need, or I'm being told that I have a need to, sometimes we call it the asset freeze technique, right? It's what you illustrated a moment ago, getting money off of your balance sheet so it can grow
outside of.
Yeah. So when you're sitting across the table from that business owner, what does that conversation look like for you? Where do you start?
Well, a lot of the business owners that I work with are they've created a closely owned company, whether a limited liability company or an LLC or some sort of family owned entity, and they're interested in in bringing in other family members, and they're interested in giving a small portion of that entity, that company, to their family members and getting it off of their books and onto their family members' books. And so they've come into me and they've said, what is the best way to allow this company to trickle down to my children, for instance? And so what we'll look at is, in most cases, the grantor still wants to maintain control. So they still want to have control over the entity. They want to be able to they want to be the decision maker. So they want to have a majority interest in this limited liability company. They want to be the one who is controlling the company.
Or voting interest.
Or voting interest in this company. And so what they'll do is they'll gift a minority interest to a beneficiary, which that minority interest does have value, and so they'll give the value to a beneficiary to get it off of their books onto the beneficiary's books. And some of the when you transfer an interest in a company, you have to transfer the fair market value for gift tax purposes. You have to transfer the fair market value of that entity. But if the taxpayer is gifting a minority interest, there are discounts that can be applied. Because if you think about it, you have a family company, you're running it with your family, and I don't even want to run a company with my family, but you're running a company. No third party wants to come in and buy into that company. Oh, let me run the company with your mom and dad. No, that's so the ability to find a buyer for that company is small, and also it's not very marketable. Like, it's hard to say, hey, come invest in my company because it's me and my mom and my uncle down, and so they allow discounts because of the fact that you're giving one a minority interest, which has no control. You have no decision making, and two, it's not marketable. And so an appraiser will come in and apply a discount to the fair market value of that and determine the fair market value of that asset. So if you have $1 million and an appraiser comes in and applies a 30% discount, then for gift tax purposes, you only have to use $700,000 of your credit, but you're transferring $1 million worth of value to the next generation. So as we briefly discussed, the estate tax exemption amount for an individual is $15 million, and so if instead of using up $1 million of that $15 million, now you're only using $700,000 because you've applied discounts to the entity that you're transferring down to a lower generation.
And one of the things that, again, we just kind of see all different solutions that have been applied, right? And the thought of, like, I had a family that I work with that Grandpa had started handing out shares, right? So to his children, to his grandchildren. So all his children got 10%. All his grandchildren got 5%. Well, I worked with a client that had 3 children. So Dad owned 10%. Each of his kids owned 5%. And I could envision them being at the beach, and the 15% ownerships, the kids who own more than Dad look at Dad and go, Dad, why are you at the beach? Why aren't you working? Right? So, like, one of the thoughts that idea of we're going to take something that's very concentrated, Grandpa owns it all, and we're going to start parsing it out, and we're going to go from 1 owner to 25 owners from a standpoint of, like, decision making, signing. I mean, all the things that invites could be very problematic. However, you could take one trust and you could take all that interest and you could put it in one trust, and that trust could have all those same beneficiaries, but all of a sudden you're making decisions at one person. Like, the trustee is making decisions for that entire group. Or, quite frankly, that trust just kind of sits there until Grandpa passes away, and all of a sudden there's 15 different trusts. But there may be one trustee that's a trustee on all 15. So all of a sudden we're aligning interest, right? So it's much less fragmented. So there is this thing where it's like, if you want your business to go on for generations, there are solutions that you might want to think about other than just starting handing out shares.
Correct.
Because when you start handing out shares, it's not just like, hey, Tommy, here's your 5% interest. It's like, well, now Tommy has shareholder rights, right? So Tommy starts getting crossroads with the family. He's like, hey, I want a P&L. I want a balance sheet. It's like, whoa, that's not what Grandpa wanted, right? So it is like, there are these tools that are really designed not only for tax purposes, but they're also just like, how does business function?
Right.
And how do we keep things aligned? So there's just bring that up because it is a thing where it's like, we see sometimes we show up after the fact and we're like, whoa, we would have done it different had we been here.
Right.
Yeah.
And the same discounts would apply to if you structure the trust correctly to a gift to the trust.
Yeah, that's right. Yeah.
Yeah. One of the things that always makes folks a little bit queasy, I mean, really, when you're doing estate planning, you are assuming a future where you're gone, right? So you're talking about your death and you're trying to forecast into the future, which takes a lot of wisdom, discernment. It's hard to do well. But also you're talking about giving up some control or making an irrevocable gift.
Right.
That makes people a little bit nervous, a little bit queasy.
Right.
Talk a little bit about how that works in practice. How do you, if I'm the business owner and I'm sitting across the table and you're saying, hey, it'd probably be helpful for you to give 30% of your business to an irrevocable trust for your family now, because your business is growing at 25% annualized, and we're going to hit an estate tax wall in the not too distant future. And I'm saying, yeah, but it's my business. I'm going to give up control. Like, how do you respond to that kind of?
Well, and it is true. There is, with regard to most irrevocable trusts, they are the grantor, they are the fundor, they fund the trust, but then they're not the decision maker of the trust. So they really have to pick somebody that they trust to be that decision maker. It can either be a corporate fiduciary or an individual, but it needs
sometimes
to be
a special trustee. Like, so we see situations where, like, I work with a family that was in a very specific industry, and he had a friend that was in the same industry in another city, and he said, he's going to be my special trustee. So if I die, I want Tom from Omaha to make decisions in this business because he understands this business.
just with regard to the business.
Yeah, that's
and then
right.
there's another trustee who makes decisions
Right.
with regard to the other assets.
Yeah.
And that's
Yeah.
very true.
Yeah.
Right. And that can be, if you have, sometimes it's hard to find that person with the skills that you need to serve in that capacity. That's usually one of the bigger stumbling blocks, even with a revocable trust, is who do I name? Who do I trust enough to name as trustee?
And one of the interesting things we see, and I'm sure you see it, is that, with smaller estates, it's much easier to think, hey, Cameron's my neighbor, love the guy, he can be trustee of a $5 million trust, I'm sure he can figure it out. But all of a sudden, if it's a $20 million trust or a $30 million trust and there's businesses involved and real estate involved, all of a sudden it becomes like, well, I don't know that Cameron even wants that job.
It is a job.
Right.
A lot of my clients will come in and say, well, it's an honor, so I'm going to give it to my oldest child. I'm like, you just gave your oldest child a job.
Yeah.
It's not an honor. And
Yeah.
there are a lot of fiduciary duties that are all tied up in serving as a trustee.
Sure.
And if you don't understand what those duties are and you're just going along the premise of this is what dad wanted, you could very well end up in court. Because what dad wanted, if dad didn't write that in the trust agreement, then you need to abide by the terms of the trust agreement.
Yeah.
So
The very first P&L I saw for an auto dealer, I was in law school, and grandma, who owned the auto dealer, had made gifts to the granddaughter, and guess who wasn't happy?
the daughter.
The daughter. So the daughter comes in and starts suing grandmas. I mean, suing everybody. It's like, this isn't what anybody wanted.
Right. Yes, exactly. It's true.
Yeah. So
It's true.
it's one of those things where it's like, it's kind of an honor, but it's also like, I describe it as the greatest honor nobody actually wants.
Right.
Yeah.
Right. With a lot of work involved and a
Yeah.
lot of liability
Yeah.
involved.
Risk. Yeah.
There's
Yeah.
a lot.
So,
Which is a good quick plug to be like, don't go to ChatGPT or Claude to try to make an irrevocable trust for your
Please.
family.
Or a revocable trust, or power of attorney, or anything.
It is
of
not
that
the right
nature.
tool.
It
It
is
can
not-
inform you, but it is not the right tool.
well, and even like, I mean, it is like maybe a good time for like a PSA. Like, ChatGPT is not an attorney, right? So like, we're seeing a lot more clients that are providing self-help through ChatGPT or through Claude or through whatever, and it's a little scary
It is.
because the information they're coming back with is partially right, partially wrong,
And sometimes just flat made up.
but they're very sure, right? I mean, it's like all of a sudden, it's like, I've spent hours thinking about this. ChatGPT and I have been iterating on it. It must be right. And then you look at it and you're like, actually, and not to mention, it can be devoid of strategy. All of a sudden, we're way down the road on implementation, but nobody's asked, like, what's the actual goal here?
Right.
So,
Right.
yeah.
Yeah. No, that's a scary thought.
Well, if you're still listening to this podcast, you're probably
Which you probably are.
Probably a little bit of a nerd. But we're gonna go one layer deeper, right? Let's bring in the IDGIT, the intentionally defective grantor trust. So again, kind of, we're talking about a business owner who, the ideal, right? If you were just to say, hey, this is the perfect example of where this asset freeze techniques work. It's a young company that is very promising but has a very low value, right? Say your value is $100,000, you make a gift to an irrevocable trust, and that value becomes worth $50 million later, right? You've only used up $100,000 of your exemption, but you've gotten a large asset off your balance sheet. Well, in that case, there's this other little layer to the technique, and it's called making it an intentionally defective grantor trust, which is a little wonky, but let's go ahead and wade into it. What does it mean, and why would I, as a grantor, want to do that?
I think we need to back up a step real quick, though, and talk about the difference in taxation between an irrevocable income tax taxation between an irrevocable trust and a revocable trust.
Good point.
So a revocable trust is always taxed as a grantor trust. And that is because that even though the assets might be titled in the name of the revocable trust, for all intents and purposes, those assets are still deemed to be owned by the settlor. So all the is reportable under the settlor Social Security number.
For lack of a better term, it's a pass-through entity.
Pass-through entity.
Right? It's a little bit
tax.
like an LLC or something where it's like everything in your revocable trust is taxed to you.
So with regard to the grantor trust, the revocable trust is taxed as a grantor trust. An irrevocable trust can either be taxed as a grantor trust or a non-grantor trust. And if the irrevocable trust has certain if the grantors retain certain powers, certain decision-making abilities, then that trust will be, the irrevocable trust will be taxed for income tax purposes as a grantor trust. So once again, just reporting the income under the settlor's Social Security number. While an irrevocable trust that is a non-grantor trust, so a trust where the grantor did not retain such powers, that trust has to report its income underneath an employer identification number. So it's given its own tax identification number, and all the income has to be reported underneath that number, that employer identification number.
So that's a very important piece, kind of to all of this, is the irrevocable trust is taxed as its own entity, unless we do things to make it not taxed as its own entity.
Yes.
Right. So that's just from a standpoint of the listener, just like what we're saying is like that irrevocable trust taxed as its own entity is really an important distinction as to what it is.
And also that power, it's called a grantor trust power, you can be turned on or turned off. So you can decide through the drafting of your irrevocable trust if you want the irrevocable trust to pay the taxes or you don't. But this is really a key point because of the fact that the income tax levels for an irrevocable trust are compressed. You hit the top rate at 37% with just $16,000 of income, where on the revocable trust side, with the individuals, you don't hit the top rate, the 37%, until an individual has around $640,000 or a married couple has around $740,000. So it's very
of income. Annual income.
Annual income. So that's a huge distinction between a grantor trust and a non-grantor trust is how it is taxed. And we briefly talked about an intentionally defective grantor trust. And what that trust does is it intentionally brings in the income tax rules and makes them apply to this trust. So this irrevocable trust, will be taxed as a grantor trust. So all the income that is made on this from the irrevocable trust will be taxed to the individual. And what this allows the individual to do is to make a non-reportable gift, because you are able to leave the assets in the irrevocable trust and they can continue to grow without using the assets in the trust to pay the tax.
No tax drag.
No tax drags. But then the individual who has a taxable estate and is trying to decrease his taxable estate can pay those taxes from his own other separate assets.
Yep.
So it's basically a non-reportable gift that you have made to the irrevocable trust.
Yeah. One of my favorite. I mean, it's like, why would I ever pay taxes for someone else? Because it's a tax advantage move. I mean, it is. It's
a planning move that you are able to take full advantage of. And let's say that for now, you've decided that, I think we want it to grow and I want to pay the taxes. You can include in the irrevocable trust kind of like a toggle off, or you could say the trust protector could come in and change this trust from a grantor trust to a non-grantor trust, and then the trust from that point in time start paying its own taxes. So there are things that can be done to turn that on or off, but it's an important tax tool that I think can be used to a grantor's advantage.
Yeah. And it is even the thought of being able to have it be treated as a grantor or non-grantor trust, quite frankly, can make the grantor more comfortable, because it is a thing where it's like, I guess I'll pay the taxes for it to start out, but if at any time in the future I don't want to because my income's decreased or whatever, we can turn that off.
You can turn it off.
But I think
if it's
once,
drafted properly.
right, once people start to understand it, then they're actually comfortable with it and they want to do it. But I think that ability to toggle it on and off also just creates some comfort for the grantor.
Correct. Yes.
Yep.
Yes.
Yeah.
Another large distinction that we touched upon was the creditor protection. I often have clients come in.
Creditor protection, divorce protection. I think we should just touch on both those things. Yeah.
Your biggest creditor is your ex-spouse. It truly is.
True.
I have clients come in and say, "Hey, I need some creditor protection. I'm a Kansas resident. I need a revocable trust." And well, those are not the same. You cannot receive creditor protection from a revocable trust in Kansas. And some state laws there are some state laws that do allow for some creditor protection inside of a revocable trust, but it's all state law. It all depends on the state that you're living in.
Well, then even those, like a self-settled grantor trust in the state of Missouri, supposedly is going to provide you some creditor protection. But it really hasn't been tested that well.
Well, and that particular trust that you're speaking of, it would only apply to creditors of either the state that you're in or a state that also has a similar law.
Right.
So you have to be very picky on who your creditor actually is, which we don't usually get to pick.
Yeah.
Typically, no.
Typically not.
Yeah.
So, with a revocable trust, a purely revocable trust, you even when the settlor passes, those assets in the revocable trust are subject to their creditors. Or an irrevocable trust, for the most part, they would not be subject to the creditors of the settlor.
Yep.
But we spoke briefly about a revocable trust becomes irrevocable upon the death of the grantor. And so when that shift happens, the creditors will have 6 months to come and make a claim. They don't make a claim against the trust assets. Those assets will then be distributed to the beneficiaries. And if your trust is correctly, it has the right bells and whistles, the assets that are in those trusts that are created for the beneficiaries will have asset protection as well. So those assets can be protected. So if your child...
Even in that 6-month time frame after the death of the grantor?
Yeah, as long as the creditors don't come and take everything. As long as there's assets to go to them.
Right.
So if there's assets there, those assets will have creditor protection. And divorce protection is the biggest, is a key to all of that. So you protect your children from themselves. And
Well, it is interesting, those of us that are comfortable with trust love the thought of an irrevocable trust, right? I tell people all the time, like, if somebody walked in here today and they said, I'm going to give you $10 million outright, or I'll give you $10 million in an irrevocable trust for your benefit, I would take it in the trust for my benefit every day.
Yes.
Right?
Yes.
And so it is this thing where it's like, it's such a powerful tool that people that aren't comfortable with trust often are like, I just want to give the money to my kids. And it's like, it may not be the most advantageous thing to give the money, just give it outright to your kids.
Right.
So that's what these irrevocable trusts are, super powerful tool, and they just provide so much leverage. So it's,
And we haven't even touched upon the generations giving transfer tax exemption leverage that they also would allow your children, would allow you in the irrevocable trust, if you've applied your generations giving transfer tax exemption to the trust, that those assets can stay in trust and go down generation to generation to generation without being subject to generations giving transfer tax.
Or estate and gift tax.
So that's, it's a very powerful tool for the right set of clients.
Yeah, we ran some math the other day, and if you put $1 million in an irrevocable trust and it sits there for, I think we ran it at 50 years.
50 years, yeah.
$1 million today at 50 years at an 8% return, it's like $80 million at 50 years. So it is this thing where it's like, I mean, just that compounding interest is such a powerful tool that it is just like, but you don't think about it because it's like, well, I'm just going to leave $1 million to my children. I'm going to gift $1 million to my children. It's like, well, let's think about it in a big picture standpoint.
Right.
Yeah.
One thing that for your set of clients especially that we'll need to keep in mind though is that the assets that are in the revocable trust at the grantor's death, those assets do receive a step up in basis. So if you're really not worried about estate tax, but you are worried about income tax, then you need to talk about which game are we going to play. It's not easy to play both, but you can play if you're worried about income tax. Any assets that are owned by the grantor at their death receive a step up in basis. So that means they become the fair market value of that asset on the date of death. And opposed to the assets that you put in your irrevocable trust do not receive a step up in basis. They receive a carryover basis. So the basis that was the grantors is now the basis of the beneficiaries. So that's just an important
The basis inside the trust.
So it's an important distinction that should be made. It's whether or not you want to worry about estate tax planning or income tax planning.
Yeah.
Yep.
And it's usually both.
Lots of time we just like to worry.
Yeah.
I get paid to worry. I get paid to find red flags.
You're great at it. Yeah.
Yeah.
So we went over some pretty complex things, and these are jargon-laden, tools that it does take some time and to get familiar with them. Maybe at a very high level. So again, oftentimes as a business owner, you don't have to be a business owner. Sometimes just a high net worth individual, if they're thinking, okay, one more time, high level, I'm $5 million above the estate tax exemption. I want to get some of this money out of my balance sheet. What are my next steps?
There are steps that they should look into taking. One of them may be an installment sale to an irrevocable trust. So we're trying to just transfer that an asset that is kicking off a lot of income, or an asset that you think is going to appreciate in value. The irrevocable trust could purchase that from the taxpayer for a promissory note. And so in that case, you're exchanging the stock for the promissory note. And so the stock you have put into the irrevocable trust where it can grow, and then the value of that stock is frozen at the value of the promissory note. One important step that I just completely forgot to mention was that before you transfer that asset you need to have funds, a seed amount in that irrevocable trust, at least 10% of the value of the gift, because you need to be able to prove that this is not some sort of sham, that you actually have the money to pay the note, right? So that's an important step. But what that does is it freezes the value of that entity at the value of the promissory note. And so then it can grow. And then, of course, because you can't make a gift to yourself, the interest that is being made the interest that's being made inside the irrevocable trust, it can be, if it's defective, if it's a grantor trust, can be paid by the taxpayer, which is another reason where it's allowed to grow. And since you can't make a gift to yourself, that payment is not considered a gift. The payment of the income tax is not considered a gift. So there are just ways that you should probably think about trying to transfer some assets out of your estate, and what's the best way to accomplish.
Well, and wins, right? So like we have, I call it the double move, right? So this thought of like, I'm building a business to sell, or I've founded a business to sell. The best time to transfer that to a irrevocable trust for my family is early, when it's got very low value. So that's the first move. And then the second move is we want to transfer portions of it to charity right before the sale when it's got a high value. So if people hear nothing else in this, it's like, if you're building a business to sell, or if you foresee selling a business in the future, the thought is the earlier we can make that transfer to a trust for family members, the more leverage, the more powerful it is. So that's kind of this is a thought of for business owners, tech entrepreneurs, that kind of thing. That's really the playbook. That's what we want to try to do.
Well, and you'd mentioned transferring to a charity. The issue there is if you transfer the asset in kind to the charity, and then the charity ends up selling the asset, then the charity recognizes the gain opposed to the taxpayer. Before selling a business, it's often a good idea to talk to your estate planning attorney.
Well, and the interesting thing, and this is what, like, we have a good friend and client that basically there were kind of some rumblings that there may be a buyer out there, right? So we made some moves kind of with the thought of, hey, the thought of selling this is actually becoming more real. So we made some gifts to an irrevocable trust. The initial buyer that we thought was going to buy it actually went away. But 3 years later, we ended up selling the business. But the fact that we'd made that gift that much earlier made the impact that much greater.
Right.
So it is this thing where it's like, if you're thinking, I might sell my business someday, even if it's to an internal sale, to a strategic sale, like, come talk to a tax advisor, because there may be some things that you can do today that have basically no impact on the operation of your business, that have huge leverage later on. So like the
True.
sooner we get on the ground and can help, the more impactful we can be.
It's true.
Yeah.
Very true.
So
Yeah. And then also, Aaron, if I own a horse and I need an equine trust, I
am
hear
your
you're the person to go
I am
to.
your
Yeah.
person.
All
Yes,
right.
I am.
That's
I represent all the horses in Johnson.
that's right. So just
this is not a paid
FYI.
advertisement.
Great. Well, yeah.
The choice of a lawyer is an important decision.
So yeah, we were in the deep end of the pool a little bit today. These are, if you're still listening, this applies to what you're thinking about. Like, happy to talk more about it. It's often not something you get on the first draft, first go through, but really, really powerful tools. And when utilized appropriately and with the proper wisdom and direction, it can have really a multi-generational impact.
It can.
in your family. And
It
so, Aaron, thanks for sharing your time with us today, your thoughts, and really appreciate it.
Yes.
Yeah.
Thank you.
Thanks, Aaron. Thanks, Cameron.
Yeah.
Thank you for joining us on the Story Lens podcast. If you're navigating complex financial decisions, we're here to help. We know your story is anything but ordinary, and that's why we start there, because the right solutions are as unique as you are.
Story One Family Office, LLC, or Story One is a registered investment advisor, RIA, registered with the United States Securities and Exchange Commission, SEC. Registration as an investment advisor does not imply a certain level of skill or training, and the content of this communication has not been approved or verified by the United States Securities and Exchange Commission or by any state securities authority. Story One renders individualized investment advice to persons in a particular state only after complying with the state's regulatory requirements or pursuant to an applicable state exemption or exclusion. All investments carry risk, and no investment strategy can guarantee a profit or protect from loss of capital. Past performance is not indicative of future results. This podcast is intended for informational purposes only and is not intended as the sole basis for financial decisions, nor shall this be construed as advice for the financial needs of any individual. Story One is not permitted to offer, and no statements made during this podcast should constitute legal or tax advice. The information contained herein has been compiled by independent third parties, have been obtained from sources who are believed to be reliable. However, accuracy and completeness cannot be guaranteed by Story One.